Today, we are going to be talking about the district attorney's declination of charges, declining to file charges on Taylor Frankie Paul. When I saw the news, I also saw that I started getting quite a lot of questions. And so even though there's a, hey, this is just what happened, there's still a lot of questions about why that happens, what that means, what happens now, what is not said. I have the actual release from the district attorney's office so that we don't have to go grab it just from media. We will go also look at some of the media reports, but there's a lot of questions about how does this happen? What does this mean? And I figured that since I have worked as a filing deputy where I'm making those decisions about filing charges, not filing charges, it might help to go through what that decision-making process looks like, what it means, and then answer your questions, because there really were a lot of questions about this. This is a declination letter, or a letter declining to file charges. So this is Draper Police. This is coming from the Salt Lake County District Attorney's Office. It says it's coming from their Family Protection Unit, probably because they do not call it the domestic violence unit, based on the information provided to our office for screening. What do they mean for screening? They mean that they are taking all of the police reports and screening it for filing charges. So the district attorneys get the police reports and then decide what, if anything, they are going to charge. They decide if it is a felony, if it is a misdemeanor, if it is something that is further investigation. So let's talk about that process a little bit before we get into this more. In a lot of jurisdictions, and this can vary, there are some jurisdictions where law enforcement picks what charge they think applies, and then it gets arraigned, and then the district attorney's office can modify it. Different jurisdictions do this differently. In Utah and others, the police take all of the reports and what they know to the district attorney's office to file them. That happens in a variety of ways. Sometimes you just get a stack of papers from the police department with a note on the top, and then a date if someone was cited out on a ticket or whatever. And then the filing deputies get all of that, read all of that, decide if there's charges, not charges, or if it needs follow-up or more information. Different cases that need more nuance, you will have an officer come in, sit down in your office, or normally a detective, sit down in the office and tell you about what's going on in the case. Sometimes filing deputies will interview witnesses, victims, etc., before deciding to file a case. Sometimes, if you're in a special unit, depending on how the office is set up, sometimes it will go to the deputy that might be the one in charge of the case, and they will be the one making the filing decision, not a deputy that does that all the time. So it really, and when I say deputy, I mean deputy district attorney or, district attorney. Some places call them assistant district attorneys. So it will go to the attorney that's going to have the case, and they will do that. Oftentimes, if you are dealing with cases with vulnerable victims, you will have a specialty attorney assigned, and they will talk to the victim before charges are filed, or should, and talk them through what that process looks like, what happens next, and make sure that they really should, as I say, should, understand what's happening, what's going on, what's happening next, etc. So there's a couple different ways this happens, but from police with all the reports to the district attorney's office, and then a decision is made. That's what this letter is talking about. Again, that decision can be charges are filed, charges are not filed, more information is needed, further investigation. Those are really your options when it goes to the DA's office. Draper Police gets this letter from the district attorney's office, and the district attorney's office also let the public know that based on the information provided to our office for screening for charges, we are unable to proceed with the prosecution of Taylor Frankie Paul at this time for the following reasons. It is my understanding from what was said in court that the prosecution was evaluating charges against both Taylor and Dakota. This does not say Dakota. This only says Taylor. It might be that that wasn't announced. It might be that they haven't made that decision yet. We do not know. So I am not making any assumptions or guesses about whether or not they will file charges on Dakota. I don't know, but they don't say that here. The following reasons, evidentiary issue. They don't have enough reason. They don't have enough evidence to follow through. Let's see what they say. After reviewing reports and evidence submitted to the Draper Police Department and West Jordan Police Department, the Salt Lake County District Attorney's Office has declined to file charges against Taylor Frankie Paul. The complainant in these cases reported several incidents, not just the February incident, some of which occurred more than 3 years ago. Any incidents of misdemeanor offenses which are alleged to have occurred more than 2 years ago are barred by the statute of limitations. Incidents which are alleged to have occurred within the statute of limitations have been reviewed. Several incidents that were submitted do not rise to the level of criminal offenses. The remaining incidents lack sufficient evidence to support filing criminal charges, where the state must be able to prove such allegations beyond a reasonable doubt. Such incidents lack specificity as to when and what actually occurred or corroboration. Based on the evidence submitted for screening by Draper Police Department and West Jordan Police Department, the Salt Lake County District Attorney's Office declines to file any charges. We would be happy to revisit this matter if additional information is developed which supports the prosecution of the suspect. So, they are not talking about whether or not Dakota will be filed. They are not saying, we think we need more information. If that was true, they would reach out to law enforcement and say, hey, we need this. Can you do further investigation? It would just be referred for further investigation. Do this investigation, bring it back to us. That's not what happened. We are declining to file charges. We are finding that there are some things that were reported to us that are more than 3 years old, which would put them closer in time to when the first incident she was prosecuted for happened, which the time to report that is when that incident happened. I know that there are complex and varied reasons why people do not go to the police when things happen, but there is nothing that can be done about the statute of limitations in this case. Some statute of limitations are much longer, but when we're talking about misdemeanor cases, you can't report it beyond the statute of limitations and have them go back and say, okay, well, now you are ready to report it, so now we can do something about the statute of limitations. That does not count here. In some cases, the statute of limitations doesn't exist at all, like first-degree murder. In some cases, the statute of limitations has been expanded so that charges can go back further. That's not the case here. So this will go to the court. What's interesting is that this does not address the probation violation. However, some of the media articles do. Leonard, have you seen this story coming out about the FBI being hacked? I know. The FBI! Right. Early reports at the beginning of April indicate that foreign actors were able to hack into the FBI and get into the systems that they use for wiretapping. The FBI can't keep their systems secure. What hope is there for the rest of us? Well, that's why I have Incogni. Incogni goes out to all those data brokers and gets your information taken down. But it's not just that Incogni does this once. You sign up once and then their system is fully automated and it keeps scouring more data brokers. And Incogni is one of the only places that I've seen offer a custom removal feature where you can work directly with Incogni privacy experts to handle specific and customized takedowns of information online. Plus, you can see where your data is getting removed from, which helps you take back control of your personal data. And you're not constantly scouring the internet trying to see if one of these leaks impacts you, because it's just handled. Incogni knows you're going to love it. And just in case you don't, they offer a 30-day money-back guarantee, so you can cancel anytime. Leonard, I know you're ready to check it out and take back control of your personal data with Incogni. Just go to incogni.com/Emily and use code Emily to get 60% off annual plans. And Leonard, I know you will rely on Incogni as much as I do. Now let's get back to today's case brief. Taylor Frankie Paul won't face charges over alleged domestic violence incident with ex-Dakota Mortenson. Prosecutors have declined to press charges against Taylor Frankie Paul after a pair of domestic violence investigations earlier this year. The Salt Lake County District Attorney's Office said in an April 14th press release that it would not be pursuing charges against the Secret Lives of Mormon Wives star, 31 years old. According to the release, The cases were reviewed by multiple attorneys because of the high profile of the defendant. Interesting. In February, 2 Utah police departments opened separate domestic violence investigations into alleged altercations. I should probably just call them altercations instead of incidents, because incidents keeps getting harder to say the more I say it. Between Paul and her ex-boyfriend, Dakota Mortenson, 33, who share a 2-year-old son, Ever. In April 14th, letters to both departments obtained by people, the district attorney's office said several of the alleged incidents investigated by police took place more than 2 years ago, meaning they fall outside the statute of limitations. The other alleged incidents do not rise to the level of criminal offenses or lack sufficient evidence to support filing criminal charges. Prosecutors went on to state that some of the incidents lack specificity as to when and what actually occurred or corroboration, which is a huge problem. You need to know what happened and when. You cannot file charges on stuff. They say that the district attorney's office also said in its press release that the investigations would not affect Paul's probation status stemming from a previous 2023 arrest and indictment, and that no additional individuals were screened for charges. Oh, there's the answer. It's hidden at the bottom. So they weren't screening Dakota for charges. So no additional individuals were screened for charges in connection with these investigations. Okay, well, there's the answer. There's the answer. It could be that they asked her, do you want to press charges or do you want to pursue this? And she said no. That's very possible. And so he wasn't even screened. The only outlet I've seen report that no one else was screened is People. I'm going to keep looking for a second source. However, just knowing how thoroughly people's lawyers vet things, I am interested to see if I can find another outlet reporting the same. Taylor Frankie Paul is not going to be charged. We heard in the hearing on April 7th, the guardian ad litem indicate that both parties were being screened. People has reported that in the press statement, not the letter, but in the press statement, that no other individuals were being screened for charges, which indicates that they were not screening Dakota for charges at all, which could simply be because Taylor Frankie Paul said, I'm not pressing charges. I don't want to press charges, which is fair. We also know from reporting, I think only from People, that they are not pursuing her probation violation, which is a bigger deal to me, because the probation violation they would have been evaluating is what happened in February. So if it doesn't even rise to the level of a probation violation for them, then what happened in February is something that's not even going to violate her probation to not have further incidents. I think that is the biggest signal to me that, at least with regard to what Taylor Frankie Paul did in February, the district attorney's office is not concerned about it. If they were, they would violate her probation. But they're not. And that speaks volumes, because a probation violation is a much lower standard than beyond a reasonable doubt. And if they are not pursuing that, they think that whatever Dakota said that Taylor did does not even rise to the level of meeting that lower burden, because that could be based just on Dakota's statement if believed. And so whatever happened in February is not enough to violate her probation. And somebody on probation for domestic violence that is in another domestic violence incident, most attorneys are concerned about that enough that they will violate the probation. That's why you're on probation. Because if you're still having incidents, that can become a very volatile and dangerous situation to everyone involved, especially when there are children. Which brings us back around to, but what about that video? She was already prosecuted for the video we've seen publicly. What about the video that the guardian ad litem was talking about? Because in court, the guardian ad litem was talking about Taylor pushing Dakota with him holding Ever that would have fallen in this period of time. It seems that the prosecution was evaluating everything and chose to not bring charges. So it doesn't rise to the level of charges. There are older incidents that are beyond the statute of limitations, and there are some things that are just not specific enough in time and without corroboration to bring them forward. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.